So guys, welcome to Scott's Legal Channel. So in today's episode, we're going to look at arbitration, an alternative way of dispute resolution. So the theme of this topic is empowering the youth in alternative form of dispute resolution and empowering the youth in arbitration as a way of resolving disputes. So you're going to be informed by Senior Counsel Charles Kanjama, who happens to have a lot of information in this field of arbitration, and is going to educate us more about arbitration. He's going to disclose a bit about arbitration, the cost and everything. He's going to give us all the legal advice, knowledge that we need when we want to venture in the field of arbitration. So he's going to talk to us everything about arbitration and small claims court and everything, the relationship between those claims court, arbitration, and the digital technology in relation to arbitration and everything that concerns arbitration. So Senior Counsel Charles Kanjama is going to unravel all those things, and we're going to understand about arbitration, and we're going to venture as youth in those fields of arbitration and become young arbitrators to resolve these disputes, because much of today's disputes are being resolved through the alternative ways of dispute resolution. Less disputes are being resolved by the court or through the court processes. So this is the feature of the law of dispute resolution. So let's hear from the Senior Counsel Charles Kanjama, and I think we shall understand about arbitration.
The topic of this session of ours is innovative and sustainable solutions. I would like to say that in my experience in arbitration, I have found that each of these four attributes of arbitration are being challenged by the way we are practicing arbitration today. First, I discovered that arbitration is actually quite pricey. It's more costly than handling a case in court if you are speaking about the legal fees of the dispute resolution panel. The most expensive cases in our courts, you pay a filing fee of about 70 to 75,000 shillings. If it goes to 100,000, that's the top limit. Even if you are handling a case of 10 billion shillings, 30 billion shillings, there is a cap to the legal fees that you pay the dispute resolver. The lawyers who are handling cases in court, well, they will charge based on their seniority, their competence, and their ability to negotiate with you. But you will find that many of them, you are likely to find lawyers who will charge reasonable fees. When we go to arbitration, the costs of the arbitral panel are more expensive. When I do my typical domestic arbitration, I'll not talk much about international arbitration. Senior Counsel Haga has talked to you quite a bit about that. But for domestic arbitration, typically the arbitrator charges fees after they finish the arbitration process. The cheapest arbitrations will find the fees about 1 million shillings after the hearing. And sometimes they go to 2 or 3 million shillings. So one of the challenges of arbitration for us here in Africa that requires a solution by the youth is the question of cost. And the Chartered Institute of Arbitrators even came up with new rules to try and encourage more economical arbitrations. But somehow it's not working. Arbitration still seems to be having that elitist tag of there are not so many arbitrators, the costs of arbitration are quite high, we charge per hour. Like myself now as a fellow of the Chartered Institute, I'm meant to charge 20,000 shillings per hour when I handle a case. You see, that's quite pricey. So the hours pile up. And I know for many of you here, you're thinking, wow, I'd like to be a fellow and charge 20,000 per hour. Why is this fellow talking to us about cost? But we are thinking about arbitration from the perspective of solutions that are sustainable, because that is the topic. And that has been one of the challenges. When I was the chair of the Nairobi branch of the Law Society of Kenya, a proposal was made by the judiciary to establish small claims courts. And they were funded by some development partners. They did some work, they came up with a bill. And the initial draft of the bill was saying that small claims courts should have a pecuniary limit of 100,000 shillings. We lawyers in practice began by resisting, saying, why are we establishing these small claims courts? Why can't we make magistrates courts more efficient? And then there was a provision in the draft that any person could represent someone going to the small claims court. We said, your work is being taken away from us. What is this? My members in Nairobi branch told me, Kajama, we need to be very concerned about this issue. Then, 2-3 years later, because the bill had not yet been passed, it was still being processed, they changed the upper limit to 1 million shillings. And I remember getting feedback from lawyers, my colleagues, and they were telling me that, Kanjama, this is a problem. It is taking away our bread and butter. 1 million shillings. I went for a meeting of the National Council of Administration of Justice, and I told them, why don't we set the cap at 200,000? Initially it was 100,000. Why have you increased it to 1 million shillings? This is taking away lawyers' bread and butter. Eventually, the bill passed with a limit of 1 million. So cases where the subject matter is below 1 million shillings, you go to small claims court. We lawyers, we resisted a small claims court of 1 million shillings. We wanted a lower jurisdiction. Of course, we got amendments to the bill to allow lawyers to appear, because initially it was saying lawyers cannot appear. But nonetheless, there was some resistance. Now, today, if you talk to the average practicing lawyer in Kenya, they have fallen in love with the small claims courts. They are quick. Disputes are resolved within 60 days. They have sealed a gap that was there of dispute resolution that was too costly and time-consuming for small disputes. The same thing happened in 2020 when COVID came. The courts decided to set up virtual courts, digital courts, and the rollout of those virtual and digital courts was a disaster. There were delays, there were inefficiencies, and I was requested to represent lawyers in a committee of the National Council of Administration of Justice. And the feedback I received, lawyers were saying, we want to have the access to physical court. We want to go to the corridors, to file documents in the registry, to do this, to do the other thing. And I found myself in that committee questioning the wisdom of this rushed implementation of online and virtual courts. Eventually, they were implemented. You talk to lawyers across the country, and we are in love with our virtual and online courts. That would have taken 10 or 20 years if it was not for the COVID crisis. Because our technology was going very slow. They have sped up access to justice. They have made it easier. So we find also in arbitration, which is meant to be fast. I have friends who do arbitration that are not lawyers. One of them tells me, Kajama, you know the problem with you lawyers? You convert arbitration into another court process. You make everything too formal, with pleadings, plaint or claim, witness statements, list of documents. Give me 21 days to file my documents, 21 days, technical objections, preliminary objections. You're making arbitration take too long. And arbitration can either be formal or informal, and the rules of the Chartered Institute allow for both. But again, the promise of arbitration being cheap is now becoming a challenge. Being fast is also gradually becoming a challenge. When I handle arbitrations after the preliminary meeting, I find that because of the timetable that the lawyers have agreed upon, the next time I will meet them might be 3 months down the line. And I start wondering, is this the speed that we need to have in arbitration? So again, there are areas for innovation here. And then on the question of finality, I've also found the question of finality is becoming open to challenge. First of all, when you get your arbitral award, you have to file it in the High Court and ask the High Court to adopt the arbitral award. And what happens is many of these proceedings for adoption of the arbitral award may take up to a year, with a lot of litigation and counter applications by the parties. And you find it has become very common for the losing party in arbitration to file an application to set aside, which is like a disguised appeal. Even though they may only succeed in 10% of cases, they're still being filed. So you may find that you've taken 12 months after you got your arbitral award to get a decree that is enforceable. And even on the question of privacy or confidentiality of arbitration, because the process then goes to court, the privacy then, the cloak of privacy then gets lifted in the process of enforcing the arbitral award. So what would I like to suggest to yourselves as young arbitrators or young aspiring arbitrators? I would like to suggest the following, that when the judiciary a few years back did a survey of dispute resolution process, they were shocked to discover that less than 10% of dispute resolution, I think it was even less than 5%, is handled through the courts. There is a lot of opportunity for dispute resolution professionals. Not only in the case of international arbitration, which of course there's tremendous opportunity there, but even in the case of domestic dispute resolution. We need to find solutions that can enable more people to access this alternative dispute resolution, including processes and mechanisms that function like the small claims court. Even now in your respective universities, you have...
That is the end of arbitration by Senior Counsel Charles Kanjama, and I think we have been informed about arbitration. He has disclosed actually everything, almost close to everything about arbitration, and I think we can venture into the field of arbitration and become good arbitrators as youths. So I encourage us to become arbitrators and to venture even in the field of alternative dispute resolution, rather than just staying or focusing on the litigation field. So you can also venture in activities like the pro bonos and to offer pro bono services and legal aids. So get in touch and subscribe to Scott's Legal channel for legal aids and lectures, and all shall be well, and you shall have the information that is pertinent in law. So have a nice day.